audience.
Namaste to you as well. Doing very well, Snehal. Thank you. So, what really happens when an employer undergoes a corporate change, specifically for H-1B employees, and also if the employer has filed a green card perm application?
Yes, that's a great question, Jaya. So anytime there's a corporate change, a foreign national that's on an H-1B, of course, gets worried, right? Because it's an employment visa that's employee specific. And this is particularly concerning for many of our clients from India that are on H-1Bs, are in the process for green card, and their employer is going through, let's say, a merger and acquisition, which is fairly common, right? Especially because we know these backlogs for our Indian clients go back, a decade or more. So obviously during that time frame, things happen. And depending on the type of corporate change, we'll have, different results from the immigration law standpoint. So we know in the H-1B context, right, when there is a material change in the terms and conditions of employment, an amendment has to be filed. And we talked about this in the past. Material change could be a change in the job title, work location, full-time to part-time employment. Those are considered material changes. However, an amendment is not required, even though a corporate change would be deemed a material change. Like it's, a little bit unusual, right?
Yeah.
But the rules say that when there is a reorganization resulting in a new corporate entity that succeeds the interests and obligations of the original employer, we don't have to file an amendment. Okay, if the terms and conditions of the employment remain same. This is what we call a successor in interest, where the successor has to demonstrate that it's maintained the obligations, interests, liabilities of the original employer, and they're still going to operate the same kind of business as the original employer. And this is normally determined by USCIS on a case-by-case basis. And so, we need to take a look, what exactly are the specifics, the legalese of the corporate change. Now, the liabilities and obligations that we're referring to are those that are linked with the labor condition application. And we've also discussed the LCA and other shows, and we know that the LCA has a number of, employer attestations and promises, information about the job title, work site, salary. So even if the new entity qualifies as a successor in interest, we may have to file an amendment or a change of employer if there's a material change related to those things. So we have let's say a new corporate entity, but now they're changing locations. Okay, they're assuming everything, all the, liabilities and obligations, but there is a change in location. So now that's considered the material change. So an amendment would have to be filed. But if everything remains the same, then the new employer, the new entity, okay, they have to document the public access file. Basically, putting in a notarized statement that says that they're going to assume all of the liabilities relating to that LCA. So that's a requirement. And those of our listeners on H-1Bs that are traveling after a successor in interest situation, they're going to need to carry a letter that explains that there is this new corporate entity that succeeded into the interests and obligations of their original employer. Now, with respect to the green card, okay, so those rules are similar, but a little bit different. Because we can't modify a pending labor certification or PERM, we wait until the PERM is approved, and then the successor company would file the I-140 petition. If the I-140 is pending or approved, then the successor in interest has to file an amendment of the I-140 and again prove that it is a successor in interest. And then immigration is going to make a determination based on the evidence. So a successor in interest, can be tricky. So if you have any questions about, how a recent company merger may affect your H-1B or PERM or I-140, please call us so we can be sure that, you don't have to start a process over or fall out of status because it wasn't done properly or timely.
Yes, absolutely. Thank you for that, Snehal, and helping you navigate your way through all of the legalese. The NPZ Law Group is there to help you. All you need to do is log on to visaserve.com or call them at 201-670-0006. And to better assist you, NPZ's US and Canadian lawyers are available to meet you with you, whether it's both in US